Let's talk about this with legal analyst and expert friend of the program, Andrew Lieb. He joins us now. Andrew, good to see you. I know you've been following these stories very closely, and we have been relying on your expertise, especially throughout this one specific Trump legal case, that is the Stormy Daniels hush money payment case. The trial now scheduled to begin March 25th next year. Why so long away?
I don't think that's so long in a trial. We were all saying from the beginning it was going to be about a year out. You see, Andrew, the key is that they have to get through the evidence. Trump's team gets rights to the evidence, and that's what happened today. Judge Merchan went over the protective order that he issued and how Trump's team, and Trump particularly, is going to have access to the evidence. Until they get the evidence and evaluate the evidence, they're not going to be able to bring suppression motions and decide what's going to be admissible. It's the orderly course of stuff, and I don't think it's so far away at all. I think it's actually in exactly the time it should be.
All right, you think it's exactly in the time it should be. It's right in the middle of primary campaign season, and a couple months after that, we could potentially know who the GOP nominee will be for the 2024 election. How is that going to factor in? He has to be there in person. He cannot campaign or have anything that deals with his campaign interfere with these mandated court appearances.
You know what's interesting about being an attorney or a party in a litigation is the judge doesn't care what your schedule is. It's all about the judge's schedule. So when I said it's exactly when it should be, clearly it's a terrible time for Trump. 3 weeks after Super Tuesday, it's going to interfere. He has to make himself available. I think the judge actually said something like, you need to make sure that you clear your calendar or something like that today. But at the end of the day, when I was saying that it's exactly when it should be, I'm talking about in the course of the matter. From when he was first arraigned to the fact that we had this order, this protective order that was issued a few weeks back, about 2 weeks back. And today, how we had this virtual appearance by Trump to explain the order. So again, if anyone out there thinks that a judge cares what your schedule is or where you got to be, you're sadly mistaken. This is the judge courtroom, and you're going to do what the judge wants on the judge's timeline. And that's just the way it goes. Okay. I have plans, and then the judge changes them for me.
Okay, because it has been different in the past. In the last, two cases that have gone to trial, he has not had to appear in person, especially in the E. Jean Carroll defamation suit that just wrapped up. It's now ongoing again. We'll get to that. He didn't have to appear.
Yeah, so, Andrew, the big difference is that wasn't a criminal case.
Okay.
That was a civil case. And that was SDNY, and this is Manhattan. It's a different jurisdiction, but again, criminal v. civil. In a civil case, your attorney better show up or you default. But in a criminal case, you gotta be there. And that's what we're talking about, the gravity of the situation, appreciating the rule of law. And that's why Donald Trump, just like anyone else, would have to be sitting right there as we were going forward in a criminal case.
Okay, Andrew, I want to talk about this protective order that he cannot talk about the case on social media. Andrew, you and I both know the former president is physically incapable from talking about all of this to his millions of followers on social media. What is the penalty if he does, and how would that jeopardize the trial?
Well, let's start off by saying that's not exactly what the protective order says. So he can talk about the case, and Judge Merchan went out of his way to express that he could defend himself, and it's not a First Amendment issue, and it's not a gag issue. Even if it was a gag issue, the U.S. Supreme Court back just a few years ago in 1991 said, if we're not talking about restricting the media, we don't really get to First Amendment. That all being said, this is a protective order. And the criminal procedure law in New York State, it's section 245.70. It's a standard operating procedure where you say, hey, listen, we're going to provide you with evidence. You can't take that evidence from the people and go put it out in the public, because that's going to impact the jury pool. That's going to impact the public. So what they're saying is limitedly he's restricted. Okay. He can't talk about the evidence that he's given. He can't talk about the people that are prosecuting him. He can't talk about the witnesses and he can't talk about the police. And then there's certain information about this electronic information, about personal information that he's not going to be able to put out. But overall, he could defend himself, and it is not a gag order. Just to be crystal clear, this is in the criminal procedure law. It was based on an application by the people. And I think it's a regular, routine, and habitual thing that happens in both criminal and civil cases. People don't like to have discovery disclosed to the public.
Okay, and just to remind the viewers, Trump pleaded not guilty last month, 34 counts of falsifying business records. He's denied any wrongdoing. We've heard him call these things a witch hunt time and time again. Andrew, I want to move on, though, to yet another story we have brought you on to talk about, and that has to do with the columnist and the journalist E. Jean Carroll. She's making more moves just in the last 24 hours. We now know that she is now seeking at least $10 million more in that court filing filed yesterday that seeks to hold Trump liable for remarks he made after the original verdict just a couple of weeks ago that found him liable. Comments, Andrew, that he made in that CNN town hall. So I think this is quite interesting to the viewer. How can someone like E. Jean Carroll, she was found, by a jury that Trump was liable in her case. $5 million were awarded in damages. She's adding on to that post that verdict. Is this standard operating procedure?
Well, it's not exactly adding on to the verdict. There's two cases going on. What you're first referring to is this case we just got the $5 million verdict on was based on defamatory statements that Trump said in 2022, after he was no longer president. But there's a prior case that's still in SDNY, Southern District of New York, a defamation case back from 2019. And that case was stalled. Why was it stalled? Trump argued, hey, listen, the government should be the defendant, not me. I was saying it when I was the capacity of being the president. And that would mean I didn't say it, but the president's office said it. And by the way, the president's office can't defame anyone. So that was an issue. It went to the D.C. Circuit, and the D.C. Circuit said, we don't have per se, that means automatic rules as to whether someone's speaking in a capacity or not. And the D.C. Circuit punted it back down to Judge Kaplan, who's the judge of this case. So what happened is, yesterday, E. Jean Carroll asked, and she sought by motion to amend that case to say, hey, listen, we now show malice. We now show how wrong he did. He said, I don't know this woman. I never heard of this woman. I'm paraphrasing in the CNN hall. And by that, he showed actual malice, and we need to be able to get what's called punitive damages. So again, there's two cases. One's fully resolved. That's the 2022 defamation. But the 2019 defamation is still alive. And all that happened is E. Jean Carroll sought to amend her complaint, and amendment leave to amend should be freely given. That's what we know. And so all she's saying is I need to be able to get big punitive damages, $10 million, because he's still defaming me. And that's what's before the judge now.
So, Andrew, you're thinking that, E. Jean Carroll, after the verdict, when Trump was found liable, awarded her $5 million, she's watching the Trump town hall on CNN literally the day after. He says the same things about not knowing her and really going after her character. And she is saying, well, look, this was successful here. It's going to be successful in this other case. Let's do it again.
I think that the entire social media network blew up as soon as Trump said it. And you saw lawyers, legal commentators saying all over, wow, I can't believe he did that. Wow, wow. But I don't know that I agree with E. Jean Carroll's strategy right here, and I'll tell you why. She's seeking to amend the 2019 case, and there's two problems with that. Number one is that it's possible that the judge rules that Trump did this in the capacity as president, and consequently the whole case is gone. Why didn't she just bring a new case? The second one is she's showing malice to the 2019 statements. Again, why didn't she just bring a new case? If I was advising her, I would have said, file again, bring a whole new one, do it now. So it's questionable why she's doing the 2019 case. But to be clear, I don't know that she was even watching it. Who knows what E. Jean Carroll was doing.
Right.
But I could tell you that if you put on any social media the second he said it, and you had any legal commentators you were following, everyone wrote, sue him again, sue him again, sue him again. So it's like a dumb move for her to sue him again.
Yeah. Andrew, while I have you, I just want to get your thoughts on this. We just got this statement in by some of Trump's attorneys. The Wall Street Journal reporting today, Andrew, that special counsel Jack Smith is basically done with his investigation, probing into all of this classified documents, those matters there found at Mar-a-Lago last August. This is a statement, a letter to Attorney General Merrick Garland from John Rowley III and James Trusty, lawyers for the former president, saying, "We represent Donald J. Trump, the 45th president of the United States, in the current investigation being conducted by the special counsel's office. Unlike President Biden, his son Hunter, and the Biden family, President Trump is being treated unfairly. No president of the United States has ever, in the history of our country, been baselessly investigated in such an outrageous and lawful fashion. We request a meeting at your earliest convenience to discuss the ongoing injustice that is being perpetrated by our special counsel and his prosecutors." This, by Trump's attorneys to Merrick Garland. Is a meeting ever going to happen, you think? What's the move here?
Oh, wow. This is Rowley is operating a clown show. That's what's going on. Rowley just lost all credibility in any legal circle for what he's doing here. Now, do I have any problem with Rowley and Trump asking for a meeting? No, you got nothing to lose. Do I have any problem with them doing something reactionary to the fact that Wall Street Journal is saying that we have the special counsel, Jack Smith, wrapping up that he had these 7 companies that they were subpoenaing, that all came out from abroad, and now they're almost ready to move forward? I would think that asking for a meeting is a good idea. But why is it a clown show? It's a clown show because he clearly doesn't want the meeting. Why did he reference Hunter? Why did he reference the Biden crime family? Why is that part of a 1-paragraph letter? Why isn't it about what's going on if there was corruption, if there was something wrong? If there's something wrong, Jack Smith, it should have substance, and it should be elegant, and it should be above board, and that's how you can actually get results. What was the point of this letter? To enrage his base, to get Trump's people talking, and to polarize a potential jury pool moving forward. Otherwise, you wouldn't have put words like Hunter in there. What does Hunter have to do with us?
All right, we'll leave it at that. Andrew Lieb, thanks for a wide-ranging discussion there on those major legal headlines regarding the former president, and we'll definitely be speaking again. Thanks so much.
Thank you.